Lori, can you switch off the share screen? Okay, great. All right, everyone. Thank you for joining us this evening for Big Talk 26, Party Autonomy, Use and Abuse. We have our moderator, Mr. Daniel Tan, speakers, Mr. Rodney Gomez, and Mr. Darshendev Singh. I'd like to say a few housekeeping matters before we begin. First of all, if you have any questions, please place your questions in the chat box, or you can also unmute and engage with the speakers directly. Um, I would like to introduce our moderator before we begin. Mr. Daniel Tan is the founder for Tan Chun Hao Advocates and Solicitors. The firm was established in 2010 and it's a boutique law firm specializing in construction and engineering projects in the region. Its primary area of practice covers dispute avoidance, arbitration, adjudication, contract drafting, negotiations, and in-house training for various parties involved in the construction and engineering industries. The firm takes pride in providing high-level services that also exceed expectations, both in terms of time and cost. Daniel, with dual qualifications in civil engineering and in law, brings with him over 25 years of experience in this area of practice, and when appropriate, he works closely with external law firms and contract consultants, sharing their pool of resources and combining their expertise towards ensuring that the high expectations of clientele can be met. My name is Sharifa, and I am a manager here at BICM. And without further ado, I'd like to pass the floor to Mr. Daniel Tan to begin today's session. Mr. Daniel, the floor is yours.
Thank you, Sharifa. I am privileged to be able to be present here today with two very esteemed speakers, Rodney Gomez and Darshendev Singh. Both are very well-known legal practitioners in Malaysia with vast experience in arbitration and in no particular order. And I only say briefly as neither one of them needs any introduction at all, but just very briefly, Rodney is the managing partner at Churn Delamore since 2001 and has significant experience of over 30 years at the Malaysian bar being involved in matters relating to arbitration, adjudication, conciliation, mediation, litigation matters involving construction contracts, consultancy agreements, engineering contracts, infrastructure projects, procurement contracts, and project management and implementation. He is presently the head of the firm's infrastructure and projects practice group, as well as the engineering and construction practice group. Darshan is a partner of Lee Hishmuddin Allen and Gladhill. His primary area of practice is commercial dispute resolution with a focus on complex disputes relating to construction, engineering, oil and gas, and infrastructure projects. Besides regularly sitting as an arbitrator and an adjudicator, Darshan also represents clients in international and domestic arbitration, litigation, mediation, and adjudication. Now, before we go into the topic of party autonomy, perhaps I should just give a brief introduction to arbitration for those of you who are new to arbitration. And it's a dispute resolution process where parties mutually agree to refer a dispute to an impartial third party. It can be an individual, sometimes a panel of 3 arbitrators, to make a decision on a dispute, as opposed to referring the dispute to the court litigation process. There's an alternative to the court litigation process. Now, we often forget that arbitration actually predates the formal court systems. The arbitration processes have been in place in ancient civilizations such as Greece and Rome, and were traditionally linked heavily to community customs and practices, where parties were not bound by any court rules or statutory requirements as to how the disputes should be conducted or resolved. So these, I suppose, through community customs and practices, procedural rules were developed to suit their own requirements for the community or for a particular trade or individual dispute. And the disputes were often decided by an umpire, usually a community leader or an elder. So there was a lot of flexibility depending on the circumstances as to how the parties would mutually agree to resolve any disputes that arose. Now, of course, over the years, with the implementation of court systems, statutes, in many jurisdictions, arbitration remains as an alternative form of dispute resolution, but some say, with the unfortunate straitjacket of the courts and legislations that are now in place. If we take a look at the arbitration clauses and agreements these days, you still see freedom given to parties to choose and agree on various aspects of the arbitration process, which is often not available to court litigation processes. For example, in arbitrations, parties are free to choose the law, both procedural and substantive. Freedom to choose the arbitrator or umpire as to their experience or qualifications to decide on the dispute. So it doesn't have to be a legally qualified person. It can be a lay person. That's a freedom to choose the procedure to be adopted. Freedom to choose whether the arbitration should be administered through an institution such as BCAM or the AIAC. Freedom to choose how evidence is going to be adduced, and all this whilst maintaining confidentiality, which is often lost in the court process. So some of these choices made by the disputing parties are referred to as what we call party autonomy, often regarded as an essential ingredient in arbitration proceedings that upholds the sanctity of parties' agreement. So with that, I'd like to perhaps invite Rodney first to maybe give us some understanding on the legal framework or the legal system in Malaysia with regards to party autonomy. Rodney?
Yeah, thank you, Daniel. Welcome and good evening, everyone. As Daniel set out, the topic that we are talking about today is party autonomy. And generally, when we talk about party autonomy in the context of arbitration, we deal with the manner in which the arbitral process is conducted. And in that respect, our Arbitration Act 2005 actually enshrines this motto of party autonomy, and that can be seen in various sections. If I can just read the sections. In particular, you have Section 8 of our Arbitration Act 2005, which states, no court shall intervene in matters governed by this act except where so provided in this act. So it gives the parties the liberty to proceed in the forum which they decided to litigate their disputes or differences under the contract. Also, many sections in the Act have wordings along the line, unless otherwise agreed by the parties. It gives that option for the parties to agree the number of arbitrators, the manner in which they're going to do things. It's all provided in the Act. And in fact, Section 12(1) has a very specific provision that says the parties are free to determine the number of arbitrators. So the whole Act in Malaysia actually supports the freedom of the parties to actually agree upfront certain critical elements like the place where the arbitration is going to be held. As Daniel said, the law of the arbitral process, in fact, the language, etc. It's all up to the parties to agree to it, up to certain aspects. So the framework has all been set there, Daniel, in regards to party autonomy. But as today's topic, which is abuses, if I'm correct, use and abuse, I suppose we'll come into that a wee bit later.
Okay, well, thanks so much, Rodney. Now, I think the starting point for any party going to arbitration would be, entering into some sort of agreement or arbitration clause that is incorporated into some contract that states that parties wish to refer their disputes to arbitration. Darshan, could you perhaps enlighten us as to your experience in relation to arbitration clauses.
Sure, very well. Thank you, Daniel, and very good evening to everyone. I think as far as party autonomy is concerned, the word speaks for itself. Essentially, in arbitration, the parties have the autonomy to agree on who they wish to decide the dispute, where they wish to hold the dispute, how they wish the arbitration to be conducted. So as I see, there are two aspects of party autonomy. One would be at the contract stage, where you are drafting the arbitration agreement to basically decide how is the arbitration going to be conducted and by whom. And the second would be the next stage, which is during the arbitration process. But let's just take the first stage, which is drafting the contract agreement. And there are various aspects of a arbitration agreement. But let's take one, for example, which is the multi-tiered dispute resolution provisions. It is not uncommon that in an arbitration agreement, there could be a multi-tiered provisions included for the parties to explore in order for them to exhaust it with the aim of trying to resolve the matter amicably before a party can go to an arbitration. And some of the common, I call them at the MTDR clauses, are things such as parties must go into a good faith negotiation. There must be a mediation before a party can commence an arbitration proceedings. Well, you may ask me, but what's the benefit of this? Why do we need such clause? If I have a dispute, just pergi arbitration saja lah. Why you want to, go through this whole ideation process? Well, my friends, one of the benefit is that, litigation, arbitration is, I would say, an expensive process. At the end of the day, there'll be a winner, there'll be a loser. But where you can try to resolve matter amicably, you should always consider that. And by having the parties to go through mediation or negotiation, the aim and object is to reduce time that you spend in litigating, and more importantly, cost, and you will preserve your business relationship with the other party in the event you reach an amicable settlement. So those are the benefits of having a mediation or negotiation. But then comes the question, I have so much of party autonomy and I can agree to that. Is there a downside in having this MTDR clause in my arbitration agreement? Well, my answer would be, it depends on how you draft the clause. For example, one of the reasons where parties can use as a delay tactic is when an arbitration agreement has a very complex MTDR clause. It requires you to refer the matter to the CEO, and then after CEO, you have to go for mediation. After mediation, you have to go for DRC. It's like 3 different processes before you can go to arbitration. Now, this is going to delay the matter if one of the party is not coming to the table with an intention to try to resolve matters amicably, but they're just using it as a tactic to just frustrate the process, to delay the matter. Worse still, my friends, if you have the limitation clock that is ticking, because limitation would stop when you issue the notice of arbitration, when the arbitration commences. But then you go and draft an agreement which says parties will go through mediation, party will go through this, party will go through that, and then you must have a lapse of 90 days or lapse of 60 days. Until 60 days have not passed, 90 days have not passed, you cannot be deemed that you have exhausted this process, but your limitation is kicking in just 2 weeks' time. So you call up your opponent and say, hey, chap, can we waive this provision? What do you think his answer is going to be? Particularly if you are the claimant. Obviously, he's not going to agree. And then you look back and say, why did I treat this arbitration agreement as a midnight clause, which every client, I won't say every, but many clients will treat arbitration agreement as a midnight clause. So then the other side will just frustrate it. You will drain your funds, and at the end of the day, you spend too much time, money, and you get the risk of limitation. Now, how do you safeguard this? Since I'm talking about the issues, I just give you share some tips on how you safeguard this. Will be number 1. Of course, there is benefit in including MTDR clauses. It is within the party autonomy to do it. But despite you having that autonomy, please exercise it with care. Think before you draft an agreement. Don't just copy paste from a sample that you get from ChatGPT or online Google and just put it in there. There's a reason why certain things are done in a certain way. If you make it too complicated, that thing will become counterproductive and it will come back and bite you. Whilst I agree, it's good to have some specific time frame for negotiation, so that in the event that time frame passes, if you don't settle, you can go for arbitration, but it shouldn't be too rigid. Now, what do I mean by too rigid? It's very subjective. It depends on the case to case, different project, but I guess that's a topic for another day. So Daniel, just to answer your question, one of the aspects will be MTDR clauses, and I think that's the part I have covered. Back to you, Daniel.
Okay, I think Rodney, I think you've
Yes.
got some comments. Yeah, go
Yes,
ahead.
right. Yeah, actually, yesterday I opened my LinkedIn and one of the individuals, my friend Joy Apukatan, he posed this question: is there actually is the word party autonomy in arbitration a misnomer? And to an extent, he's correct, because I think all of us who have been involved, in particular the construction industry, in the invitation to bid documents or in your tender documents, the general conditions of contract are already all set out there. And it's clearly specified that there'll be no deviations allowed. So you have to accept the clause that it is in its format. And sometimes, contractors and unfortunately sometimes subcontractors, because of their bargaining position, they have no choice and they may end up being forced to take what Darshan pointed out, multi-level arbitration clauses, And I like to share this story, talking about GPT just now by Darshan. This is something back in the 90s. I remember I was acting for a client, and he had the arbitration clause, and I think it was only about 300,000-400,000 at that point in time in '95. But the arbitration was to be conducted by a 3-man panel in Geneva. I mean, the guy couldn't afford to pursue the matter. The contractor in that particular case couldn't pursue it. So, you suddenly realize when you have various stages, multi-tiered arbitration clauses, you have places of arbitration other than where the project is situated. For example, Singapore, which is very expensive in my mind to conduct an arbitration, or somewhere else, or you have a 3-man panel that has been provided for in a contract worth only 5 to 10 million. There could be situations, and I'm not saying all employees are like that it could be driven by a different motivation, Daniel. One whereby they make the arbitral process expensive, time-consuming, leaving, like in my particular case, the client then stuck in limbo, eventually having to have a haircut of about 70,000. He says, Rod, I might as well take 70,000. What else to do? And these are the kind of situations that are occurring now with this very exhaustive, very lengthy arbitration clauses. And Darshan is correct. I've also advised clients sometimes. I say, look, my friend, you're going through multi steps. And it's not cheap. Some of the mediation processes, etc. Do you want to do that? And then they say, look, I got no choice. They rather take a bigger stand on clauses related to limitation or other major clauses, and arbitration clauses just okay. Never mind. Don't worry. It's a theoretical thing until it becomes a problem years down the track. So the point I wanted to say that there is the concept of party autonomy, but in reality, there are occasions one party to the agreement may have no choice but to accept what is stated there. So that's what I wanted to highlight, Daniel.
So I think what you're trying to say, Rodney, is that I think contractors who are bidding for projects, they need to be a lot more robust or brave enough to try it and negotiate arbitration agreements or clauses that are more fairly balanced and fair to both parties. But correct me if I'm wrong. I remember for the longest of time there was the area of whether multi-tiered requirements in arbitration clauses were conditions precedent before going to arbitration. That was mooted for a long time, but I think that a couple of more recent decisions that say, look, even if you don't comply strictly with these preconditions, you can still go to arbitration. Do either of you have any comments on that?
I don't think that's the position, Daniel, at the moment.
Yeah.
I think you need to go through this pre-arbitration procedures. And I think the point that Darshan was saying is a very real situation. They will say if you go straight to arbitration, it's premature because you didn't exhaust A, B, C. Darshan, I think that's my view. I don't know what your view is.
I think you're right, Daniel and Rod. But I think recently there was an authority, I think where Daniel you're coming from is whether is it a jurisdictional point or is it an admissibility point? And I think there were some school of thoughts that was discussing it. But I guess that's a topic for another day. But the point that I think I would like to drive home is irrespective of whether it's a jurisdictional issue or it's an admissibility issue, you don't want to face these challenges and you should comply with what parties have agreed. But the question is, party autonomy is so wide that sometimes people include these MTDR clauses in a very rigid form for an ulterior motive, not for its original intent, which is to try to resolve matters amicably so that we avoid arbitration. It's more like we put it in to frustrate the other side from going to arbitration, from making any claim against us.
And it's a deterrent. That's what I find,
Okay.
Thankfully, of course, it's not the topic for today now with the SIPA Act. People are a bit more realistic and realize because now the employer may have to exercise the arbitration clause as well. So, that I think has been very helpful.
So it's prudent for all parties to an arbitration agreement or clause to ensure that all the so-called tiers are complied with before they proceed to, or they exhaust all those tiers before approaching arbitration.
Right.
Okay, let's move on. Talking about arbitration clauses. Now, we've seen clauses that include references to, let's say, the seat of the arbitration or the venue of the arbitration or the language to be used in the arbitration, but quite often these things are left out from the arbitration clauses. Darshan, do you have any comments to say about this?
Sure. Thanks, Dana. I think seat, venue, and language are quite important considerations, particularly when you're dealing with a cross-border disputes involving several parties of different nationality. I think as far as seat is concerned, it goes to dealing with for example, the challenges of the award eventually. And it's very important in the concept of party autonomy that you pick the correct seat. What I mean by picking the correct seat means you must do some research, my friends. When the award is going to be challenged, is that particular country where the arbitration is seated, is it pro-arbitration or otherwise? Is it a country which will interfere too much into the arbitration award? I know one particular country, I won't mention, was New York, part of the New York Convention, but the way the judges review the awards, like as if it's an appeal process, and for many years they've been doing that. Many people stayed away from that particular country. So my point is, picking the seat is not just saying, just pick whichever that is convenient. You got to do some research behind it. Number two is venue. Just because you are having a dispute with a parties of different nationality, and as what Rodney mentioned, you don't have to pick, for example, say Singapore or London or Paris. Malaysia, my friends, and now I'm carrying the Malaysian flag, and I'm being very honest, is 2/3 cheaper than Singapore. We have good hotels, we have good food, in fact, better food. And more importantly, the price you pay at Majestic Hotel is a fraction of what you'll pay when you stay in the hotel in Singapore. And if you need,
Darshan, if you do it in during the festival in Sabah and Sarawak, it'll be even more interesting. You can do it in Sabah and Sarawak, cheapest.
And still have the seat in Singapore.
And you can still have the seat in Singapore. And as far as arbitrators, if you think that you want any particular arbitrator, I'm not saying, I mean, to be fair, Malaysian arbitrators are equally good as well. I mean, there many of them were good. But if you want any particular arbitrator, you can always fly them into KL or to Malaysia. And the uniqueness is we don't need any work permits, etc. So coming back to my point, picking a venue is also very important, because at the end of the day, it goes to the issue of cost. Because you don't want just put an expensive venue, and then later the dispute is, say, 5 million, 10 million, such a small figure, and you have to fly everyone to London, pay 5-6 times your ringgit price in pound sterling, and then you realize your cost of just conducting the arbitration is skyrocketing. Then you wonder, but I had the party autonomy. Yes, but you didn't exercise the party autonomy correctly. You treated it just like a midnight clause or a copy-paste clause, So that's the venue. Language is also important, I would say, because today's world, businesses are being conducted in various different languages and not necessarily in English. For example, China has arisen as an economic superpower, and a lot of their transactions or even contracts now are being done in the Mandarin language, for example, or even certain MENA countries, they use Arabic, for instance. So you have that flexibility of having the entire process being conducted in a language that you think that both parties are comfortable in. So why pick English, for example, when you know that the parties are all contracting in a language that is comfortable to them? So think about that as well. So you have that flexibility, you have that party autonomy. You can pick your seat, you can pick your venue, you can pick your language. But the only thing is, be careful of how you draft it, which seat you pick, which venue you pick, and which language you pick. Because for example, if you pick a language which is sophisticated, you are then in a way restricting yourself to a particular pool of arbitrators who speak that particular language. Of course, some may argue you can always have an interpreter, but I always feel having an interpreter when it is a Chinese-run arbitration, for example, it defeats the whole purpose of having the arbitration held in a particular language. So yes, be clear, be specific, don't be too rigid, and most importantly, do your research in terms of where's the proper seat, venue, and language. For those clients who are here, non-lawyers, my suggestion is it's always good to get a good lawyer by your side to review your arbitration agreement, because trust me, my friend, the money you spend today, you will save it at the end of the day. If you're trying to save the penny today, you'll end up paying a very heavy cost later on and say, yeah, why didn't I pick, say, for example, Rodney to look into my arbitration agreement clause? Thank you.
I think, Darshan, you've raised a very interesting point on language, because it's not just a cross-border issue. Even in Malaysia alone, you've got issues where you've got sometimes evidence being presented in Bahasa Malaysia, and whilst the proceedings are conducted in English, and sometimes, quite often, the witnesses in disputes in Malaysia itself could be Chinese nationals or Chinese educated individuals that require interpreters that need to interpret or translate the evidence into English or BM. But that, I think, also raises the issue as to who you appoint as the arbitrator, because like you say, if, let's say, all the evidence is going to be adduced in Chinese, your agreements are drafted in Chinese, then surely you would want to consider an arbitrator who can conduct the arbitration in Chinese and also write the award in Chinese. I don't know.
And understand it, yes.
And understand it. So I don't know, when it comes to appointment of arbitrators, perhaps on that note, Rodney, any insights you can give us as to how parties should choose a suitable arbitrator?
Yeah. Now, I think it's going to depend largely on the type of dispute that will arise. So the pool, and especially if you're going to decide, I mean, I sat as an arbitrator in one where the parties were actually testifying in Mandarin, but there was an interpreter coming to me. And so Darshan's point was absolutely correct. I was depending on what the interpreter said. So I didn't get a real hand understanding of what the witness was saying. So, it really defeated the purpose, but the arbitration clause provided everything was to be in English, and the pleadings and the witness statements are all in English, surprisingly, But I think it also depends on the nature of the contract that's going to come up into a dispute. But I think the pool that we have available, and now just talking, advocating Malaysia, there's a substantial number of qualified, experienced individuals who are not only based in Malaysia, but who are also frequently flying from overseas. It's quite common. So I don't think there's a concern there about having that. And like I've seen in some clauses in the arbitration clause where they say, for example, the arbitrator shall not be a Malaysian, or in that particular case, the Chinese individual, because China was the other side. So you can carve out and exclude certain nationalities, so to speak. It's something that you're able to do. But at the end of the day, if you don't specify anything, then it's usually administered by some body. You can make your representations to a particular body why you want a legally trained individual, for example, give your reasons and let the other side comment. And I'm sure the director or whoever it is will take that into consideration when appointing the arbitrator.
Okay. Darshan, any comments on appointments?
I think one of the other important aspects of an arbitration agreement, which I think often parties, I realize, may have missed it, is the qualification and experience or the criteria that an arbitrator should have. I'm not speaking about your usual normal disputes, but I'm speaking about complex disputes when it involves a particular engineering project or a construction project that you think you need someone with a particular technical expertise. I realize sometimes it may be helpful for you to state that the arbitrator should be someone with an experience in a particular area of how many years standing under his belt and etc., because that will be useful when it comes to an appointment of the arbitrator. And why I say that is because often at times, both parties can't agree on an individual as the arbitrator. And then you're left in the hands of the institute to basically decide who the arbitrator is. And you run the risk of the individual, despite making representations, that the individual who is then appointed doesn't really fit the bill from your perspective. And as we know, whilst parties are entering into a contract, when someone wants to get into a marriage, everything is nice and rosy. But when there's a dispute, even if they know that that is the sensible thing to agree, they will sometimes may not agree to that. So I guess it may not be wrong to consider whether you should put such a criteria. I've seen it in some contracts. In fact, some PPAs, some power plant related contracts have that as well. But my only advice would be, despite including such criteria and qualification, please don't make it too rigid to the extent that you can't find the existence of this individual on the face of earth. He must have a degree from this university. He must be of this nationality. He must have resided here. He must have how many years of experience. And then you go around searching, such persons don't even exist. So don't make it too complex. At the end of the day, you can't find an individual who fits the bill. Yeah.
Okay. I just have maybe a bone to pick about arbitrators generally as to the services they offer to parties in dispute. I still think there's a lot of room for improvement on the experience and qualifications of arbitrators, because quite often you'll find, because it's an arbitration process and it's now governed quite strictly by the Arbitration Act, arbitration protocols and rules, that the arbitrator needs to have some knowledge on procedure, knowledge on evidence, and not every arbitrator has got that sort of knowledge or training or experience. And I think for disputing parties, it's important to remember that lawyers will be good in the law, they'll be good in the procedure and the evidence generally, but they may not be so good on the technical areas. And vice versa, if you appoint a technical arbitrator on a technical dispute, yes, they're good in that field of expertise, but they may be weak on areas of law and procedure and evidence. So it's a question of where you strike the balance. And maybe it's also a wake-up call. I don't know whether it's a wake-up call, but I think a lot of the panel arbitrators need to present company excluded, obviously. But, I mean, I think a lot of arbitrators out there need to, do a reality check on their own experience and qualifications to see whether they're well equipped to handle arbitration cases, and the areas that they're weak on. If lay arbitrators, then they should do some courses or read up on procedure, evidence, the law, etc. And similarly, even for legally qualified people, they must have the knack to be able to grasp technical issues. Yeah, if they're involved in construction arbitrations, they need to know a bit about the construction process, the terminology, to be really of use to disputing parties. That's just my thinking, but hopefully there's room for improvement there.
Yes, I think we may be straying a bit off topic, but I share your sentiments, Daniel, because I've always advocated, even in my present office, that there must be continued training of individuals. Nothing stays constant. There's always change. There's development, new case laws, and sometimes it's infuriating to read changes and to study things, etc. Likewise, in one of our major local institutes, if you go and check the names, I check the names on the register. There are some individuals I know who have since passed on or still on the list. And some of them I don't think I've seen in the arbitration arena for the last 5-10 years. So, the point that you said, are they abreast of what's the latest developments, the latest thinking, the latest philosophies, the latest practices? I really don't know. So I think maybe there should be a wake-up call for institutions to do a continued before keeping an individual registered on their list. There need to be some sort of continued training, education, or whatever you call it, because I think they are fulfilling a benefit to users. And users are going to take the name on that list being that they're capable, but you don't know whether they're capable now. You know what I mean? I think taking on the point I'm talking about. But that's an issue that needs to be looked at by
I think because I think one particular area that concerns me a lot is especially if we all get involved in construction arbitrations, or a lot of it is construction disputes, is the area of extensions of time and loss and expense claims. I find that very few arbitrators are actually well equipped to deal with those sort of matters. And I think that's an area that I think all of us need to have some knowledge. I know a lot of people rely on expert evidence, but what if there are no experts? Or what if the experts come and neither expert is really up to the mark to be able to, enlighten the tribunal? But anyway, that's a separate topic in itself. Okay, let's push on. We've just talked about appointment of arbitrators. Now, how about appointing authorities? Some arbitration clauses refer, let's say, to PAN to appoint arbitrators, or the AIC to do the appointment. and that the PAM rules, let's say, will govern the arbitration, or the AIC arbitration rules will govern the arbitration. What are your thoughts on the necessity for having such institutions involved in the arbitration process? Darshan?
Thanks, Daniel. Well, I think as far as institutions are concerned, I think they play a very important role in arbitration. Hence why, particularly in Malaysia, the two leading one will be AIC and also BicTok. The reason for this is because the arbitration rules that are maintained by these institutions basically tend to cover the usual issues that will crop up in an arbitration proceedings, such as appointment of arbitrators, challenge to an arbitrator, exchange of pleadings, and various other aspects of the arbitration. And most of them are aligned with what the other international institutions that are recognized do, and it's also within the context of the arbitral model law. Now, whilst one party may say, why don't I just go for an ad hoc arbitration without any institution involvement? You can do that. That's the very basis of arbitration being party autonomy. But my advice would be, it will only work when you have two sensible counsels in the arbitration and also a sensible arbitrator. Because, as I said, when there's a dispute, sometimes most of the time it's very difficult to get an agreement unless everyone is on the same thinking process. Like, for example, I just had an arbitration which is just kicked off, and one of my opponents has suggested to the arbitrator that the Evidence Act should apply. And I immediately looked up in a horror that for the last almost 20 years of doing arbitration, no one has said this, at least in my presence. So I immediately had, for the first time, take out the Evidence Act and say, hello, my friends. Evidence Act expressly say doesn't apply to arbitration. But what I'm giving an example is that you do not know who your opponent's going to be. You do not know who's the arbitrator going to be. Sometimes it's not the party's choice, it's appointed by a particular body. And then you end up having to basically go back to basics. And then either they will agree, they may not agree, or they might go either way. So I feel if you have a strong reason to have an ad hoc arbitration, just stick to institutional arbitration. Their rules are good. It ensures certainty and the basic things are there. But if you still want to have something add on to that, you can have an hybrid process. Have an institutional rule and say, in addition, I want these certain things to apply in this arbitration, which will then override to the extent that it is inconsistent. It will prevail over what is in the institutional rule. So that can also be done. It's like an hybrid kind of process. But I think to go purely ad hoc, my personal view is it can be fairly dangerous, not knowing who your counsel is going to be and who's the arbitrator going to be.
Okay. Perhaps I've just one comment to make about institutional arbitrations. I think parties also, I think Darshan gets involved in a lot of mega big cases, mega disputes, but I think for the smaller disputes, parties may have to also consider the cost aspect of involving institutional bodies, because there is a cost factor involved. So the dispute's very small. Parties may have to reconsider whether there may be a need for institutional arbitrations involvement, institutions involvement. Okay. Okay, let's move on to the actual procedure, the process, the arbitration process. Now,
if I could just add to that, Daniel, just something came to my mind. I'm not sure. I'm just thinking out aloud. Please correct me if I'm wrong. I'm not sure whether you can actually adopt the arbitration rules of a particular institute without having the institute to administer that particular arbitration. This is to deal with that issue, of course. But I mean, anyway, this is just a thought that came to my mind. I don't have the answer at the moment.
Okay, well,
But the institution will be angry
I'll give
with,
you my
with me if I
answer.
were to suggest that. I think the institutions will be angry,
Yeah.
but I don't know. This is just a thought that came to my mind.
I think Rodney has probably got experience with this, and certainly I have, in the sense that parties have agreed to, let's say, use of the AIC rules, but expressly excluding the involvement of the AIC administering
That's right.
the arbitration. So it's sort of a mishmash. They use it as a guide to save money, I suppose. No appointment, ad hoc appointment, but they use the procedure there to sort of guide the procedure.
Correct.
But anyway, whether that's challengeable in court, that's I haven't seen that yet so far. Okay, but let's move on. Come to the arbitration process itself. Quite often, parties reach an agreement as to, let's say, how much time they have for filing of pleadings, how much time they have for filing of documents, sometimes chess clock arbitrations, how much time people have to examine witnesses, etc. What are your comments in relation to the workability of these agreements reached by parties in relation to timing issues on procedure? Rodney?
Yes. I think if you look at most of the standard form rules, they provide a certain time frame, of course, with a caveat subject to agreement of the party. So, you can move away from the standard time frame of 45 days, etc., things of that nature. And usually such factors are determined at the preliminary meeting, Daniel, where we'll fix the time frames, etc. And that's where I think a lot of party autonomy kicks in a sense, during the second stage, after during the arbitration process, because arbitrators, I think, tend to allow parties certain freedom, and councils will tend to agree, I'll take 1 month to file my points of claim, defense, etc., etc. But what concerns me, and I've seen it quite often now, because the arbitral process, even before the evidence taking, can be unduly lengthened. Parties have agreed, I'll take 2 months. Then the other guy says, I'll take 2 months. Another fellow says, I'll take 1.5 months for a reply. And before you know it, a year and a bit has already gone before they even exchanging documentation and, and witness statements. And both sides then will tell the arbitrator, no, we both agreed, etc. And, I think there is something wrong with that process, because, I mean, arbitration as a matter of policy came about as a speedy resolution. I think it was one of the factors that was one of the prime movers for arbitration as opposed to court proceedings. But, I have seen, and I've been involved in cases as a counsel and even as an arbitrator, where the arbitration process, before the even award is given, is taken about 4 years from the date of the notice. So, to an extent, both parties have agreed here and there, etc. But, I think it defeats the ultimate purpose of the objective of arbitration in the first place. Our construction courts in Malaysia, in KL in particular, they can go through a complex construction case within a year and a bit, and with a fraction of the cost. So then you ask yourself the question, party autonomy, or is it council autonomy? I don't know, because a lot of the lawyers are doing it in order to assist their busy schedule. And I also could be guilty of it. I'm not trying to put down lawyers, because, we work in here and there. But I think that the arbitrator sometimes needs to take a very robust approach, especially where lawyers are, it's very common, they, by mutual agreement, 2 months before the hearing, they say, we both agree to vacate the August dates, the 2 weeks tranche of dates. And we'll go on in October. These are free dates, And, there are times, I think, as an arbitrator, you must respect, no doubt, party autonomy, but you need to show and you need to exercise some control on the proceedings, because otherwise I think the whole purpose of arbitration can get defeated, Daniel, and that's what worries me. We need to get into the international arbitration, and I think Darshan, and I think you'll be aware, Daniel, they are not so amenable to postponements, to extensions. If a schedule has been fixed, you really have to have a good reason to depart from it. Whereas our, what do you call it, domestic, as the Arbitration Act will call it, domestic arbitration, everybody is a bit more kamching. Yeah, okay lah, take a bit more time. Don't worry, I'll give you another month. And that's where it leads to an unhealthy situation that the arbitration process takes a long time, and then it starts to get a bad name. And that really worries me. And I find that lately happening quite often recently. So that's something that I feel can be an abuse of this party autonomy concept that's going on.
I think, Rodney, I totally agree with what you said. The difficulty I face as an arbitrator is how robust can you be to go against the agreement reached by the parties, let's say, to extend time for the service of certain documents. Maybe Darshan, you could share with us. Do you have any solutions to how robust an arbitrator can be?
To be fair, I don't have the answer. I do sit in a number of arbitrations as an arbitrator as well. It's always very subjective. I have been robust in some instances, and I've also in some instances to where possible accommodated the parties. But I wouldn't deny that I have particularly in one or two matters where I realized that although it was a parties agreement, it's taking a bit too long already, and we need to see the tail end of the matter. And I had to then step in to say, look, I don't think I can agree to the parties agreement. But I tried to give some form of consolation at least. I didn't just shut the parties down, but gave them a little bit of leeway, but not the full extent to what they wanted. But it's a very difficult exercise. There's no rule on how to deal with it, but I guess you just have to deal with it on a case-to-case basis.
I think that's right, Daniel. That's right. That's the only way. You need to do. You need to prod the parties to an extent. Need to highlight to them, because to be fair, also we've all got other things to do. The arbitrators all have got other matters to deal with, and as arbitrators, you need to look at it from the arbitrator's perspective. I've kept 2 weeks for a hearing, and with 3 months to go, you say, look. We both of them have agreed to vacate it. I'm stuck. It's not so easy that I can just fill in my court diary. So, I will give in once in a while, but then I'll say, look, can we take one date here, one date there? And with the advent of the internet, the particular Zoom, etc., I say, okay, now mind, let's do it in Zoom in the afternoon. A lot of them get stuck. So you need to I mean. It's not a very easy task, but there are times you need to stand firm, because otherwise the matter can just be dragged unnecessarily, and then actually the client is the one that suffers eventually.
Correct. Yeah. So I think that the trick is how to persuade the parties to agree on a shorter timeline.
Yeah, you need to find a happy medium that everybody can live with. But you need to do something, because otherwise it can just run out of control, so to speak.
Yeah. Okay. All right. Next topic is on arbitrability of disputes. Now, obviously, I think quite often we take it for granted. When a dispute arises between the parties, we just say, okay, let's deal with it. And you just go ahead and decide, hear the evidence and decide on the matter. Now, are all disputes arbitrable, Darshan?
That's a very good question, Daniel. I think if you look at our Malaysian Arbitration Act itself, I think what the words are is that you can refer a matter to arbitration unless two pointers they gave. One is it is contrary to public policy.
Yep.
Which is again, what is public policy today may not be public policy tomorrow, and what public policy in a particular country may not be the thing. And number two, it is not capable of settlement by arbitration under the laws of Malaysia. Essentially, the law basically says it's not supposed to be, cannot be arbitrated. So that is the definition that is provided in the Malaysian Arbitration Act. Now, if you were to ask me for some examples, non-exhaustive, I think these will include things such as criminal matters. I don't think you can arbitrate on criminal matters. Income tax related issues where the IRB and all is involved, I doubt you can go for arbitration. And I don't think even it extends to an employment kind of issues, which is governed by the Employments Act, where the employer says, I'm giving you a job as a clerk, $2,000 salary. In the event there's an employment dispute, 3 arbitrators in London, this thing, the staff will say, hey, hello, gaji saya pun 2,000. Macam mana saya mau pergi London arbitrate ini matter? So I guess from the, maybe I can use the word public policy point of view, the court will look at it and say, hey, hello, this is clearly, you can't have arbitration for this sort of things. But generally, commercial agreements are arbitrable, and it can be referred to arbitration. Just to take a step further, if you're talking about party autonomy, in an arbitration agreement, the parties also have the autonomy to basically dictate which aspects of the disputes in that contract can go for arbitration, or which aspect that they don't want to go for arbitration. In terms of practicality, that's a different question, because if the issues are interlinked and the nature of the disputes are interlinked, you will then end up having litigation by installment. You'll end up having a fight in court, fight in arbitration, and then there's also a risk of both court and arbitration coming to a contradictory findings. So I'm not a fan of having a split kind of thing process, unless the nature of the dispute that you envisage in that particular contract is something that you think it will not overlap with the issues in the arbitration. But the point I'm trying to drive home is that parties have the autonomy to decide the nature of the dispute in a contract to go to arbitration. Commonly, everything, all the standard phrase, all disputes and differences in the contract will go to arbitration, but you can also choose to which one you want and which one you don't want to go for arbitration.
Okay, thank you, Darshan. I think, okay, we're just about ending our session. It's already 6:27. I think it's probably a good point to end our presentation there and our discussion, and perhaps invite questions from the floor. If there's any questions from the floor. I haven't seen anything in the chat box. Sharifah, is there any questions?
We actually have a question from Tan Sri.
Okay.
Hang on a second.
Can you put it up? I can't see the chat box.
I think he's gonna ask himself. Yeah.
Oh, I see. Sorry.
Okay.
Hi guys.
Tan Sri?
Yeah.
That's it.
I don't have the experience like you guys. You guys have been there for 2 decades as an arbitrator and arbitration. I would consider myself a pretty new kid on the block. But interesting to hear what Rodney says, that international arbitration, there is simply more urgency to it. In other words, the arbitrator will be reluctant to grant adjournments and make sure the arbitration is finished. But why is that in our domestic arbitration, there's this no urgency to it?
Yeah, you see, Tan Sri, I think it's the parties that are involved. Generally, when you do with international arbitrations, it's always a 3-man panel, Tan Sri. And, you know, they at the preliminary meeting, they will fix the hearing date maybe a year and a half in advance. But, you know, it is really crystallized and fixed. You really need to work towards it. the domestic arbitration stance, and it's been since time immemorial, since the 90s when I started doing this till now, everybody is somewhat, I don't know, they're laid back. I'll pick up a phone call and go, hey, can we take off the first 2 days? Can we? And it just happens. It used to happen in the courts, Tatri, in the 90s. Now, of course, the judges are not as lenient as before. But I think it's flowed on to the domestic arbitration, and they say, no, we've got another tranche of another 5 days, just a month later. And, a slight slippage will add on to another slippage. And, before you know, 2 years have gone, and you've only finished 3 witnesses. It's happened.
I'm actually experienced the situation that you have just laid out. But would it be too much for an arbitrator to say, if the counsel is asking for adjournment, could you tell me that your clients agree to it? In my memory, I did it in court, so you know what I'm saying? Yes. I mean, is arbitrator going too far? If you say, look, you want an adjournment, look, doesn't matter, but your client really want the adjournment? I mean, the client wants to have the case finished, right? Is Arbit going too far? I mean, I'll seek the views.
That can be pretty sensitive, Tansif, to some counsels. Generally, what I've done, and I think the rest of us would do, is that I'll insist on having a preliminary meeting, not deciding on the matter via letters. Have the Zoom meeting, etc., and having a private chat with the senior lawyers. I said, this cannot continue, lah. In fact, in one matter, I had to tell people, I said, look, if this is going to continue, I will step aside, because I cannot continue with good conscience to have, a matter going on for so long when, evidence has not even started. So, I think with a slight prod and, persuasive skills of Tan Sri, you'll be able to massage and convince them to push along. But a bit hard to put a guillotine. But, they realize the need to expedite matters. I think that eventually they will get the message.
Thank you. Darshan, what do you think? I mean, is it going too far? If you ask for adjournment, could you show me a letter from your client?
I think, yeah, I agree with Rodney that I think asking the counsel whether you have instruction of the client can be a bit sensitive. But I had a matter where in that arbitration, the parties both agreed to basically for a short extension, but I guess the arbitrator then said in clear terms that this extension is going to affect the issuance of the final award, because the arbitrator has set aside certain time to basically draft it. So then he prompted the parties, please reconsider this extension of time, because if you still insist, I will respect your choice, but this is going to significantly delay the issuance of the award. So things like that, as what Rodney was saying, is try to make it in a way where you are telling them, I'm not saying no, but if I say yes, these are the consequences. Are you prepared for it? Because tomorrow, if I then delay the issuance of the award, don't then come and tell me why am I delayed. So then that may go back there and say, hey, look, maybe let's not take 2 weeks. Let's do 1 week, for example. So they might reconsider. So that could be another way, country, of dealing with it.
Okay. That's all, Daniel. That's all. That's
okay.
the question.
All right. Thank you. I think we're already past 6:30, so I think we should try and close the session now. But before I do that, perhaps I'll invite our speakers to give us some parting remarks on party autonomy to our delegates. Maybe if I invite Darshan, any parting remarks for our delegates?
Sure. What do I say? I would think that party autonomy is the fundamental of an arbitration. It is at the heart of an arbitration. It gives people the power to choose how their disputes are resolved, who decides, where it happens, and under what rules. And I think this freedom is what makes arbitration flexible and a trusted process. But, and I say but, it's not without risk. Without limits, party autonomy can lead to unfair outcomes, especially, and we've covered this, when power is unequal. That's why I think we need safeguards, not to take away freedom, but to make sure it is used fairly. So in protecting both autonomy and fairness, we will effectively be protecting the true strength of arbitration.
Thank you, Darshan. Rodney, any parting remarks?
Yeah, I mean, I always feel arbitration is a very good process, but it is very important that the users have at the forefront that the principles of arbitration must be adhered to: speedy resolution, cheap costs, etc. If the cost keeps spiraling, if the dispute takes longer, I think more and more individuals are going to search, users are going to search for alternative dispute resolutions like mediation, or even removing the arbitration clause completely. The courts, and I keep saying this, the courts are coming very, very efficient. They're very well read. Most of the judges are experienced in handling, in particular, construction matters. So at the end of the day, one must be, the practitioners of arbitration need to be practical as to what is going on, and they need to be aware of the drawbacks, especially for potential individuals and corporations who are using it. That's all I wanted to say, Daniel.
That's interesting, Rodney, because I think BICM have launched their expert determination rules. That's another form of ADR.
Oh,
So if
okay.
you want to know more about it, I think whoever here is interested, join us for the conference in July, the BICM conference.
Okay.
Okay, I think, ladies and gentlemen, thank you all so much for your time. Darshan, Rodney, thank you very much for your input today. I think it's been very enlightening, certainly for me. And I hope everybody else will take something away that we can use to our practice in arbitrations. And with that, thank you again, and a good evening to everyone.
Thank you for inviting me.
Thank you.
Thank you, guys, on behalf of BICM. Thank you so much.
Thank you.
Thank you.
Thank you for inviting.
Thanks, Darshan. Thanks, Daniel.
Thank you, guys.
Thank you. Thank you, guys.